In the code enforcement hearing, if you have a cell phone or beeper, please put them on silent or vibrate mode. When we call your name, if you come forward to the podium on your left. Thank you.
Okay, good afternoon. This is a code enforcement hearing for the City of North Miami. Today is September 4th, and I am Rafael Suarez-Rivas. I'm a special magistrate for the City of North Miami. The purpose of this hearing is to determine if a code violation exists on your property, as observed and cited by the code enforcement compliance officer of the city. If the city is not able to prove its case, the case will be dismissed and you may be free to leave. These proceedings are being recorded. Therefore, all persons who are speaking should do so one at a time to ensure that all testimony is clearly audible to the recording device. If English is not your primary language, please inform me when I call your case. We will make every attempt to have a translator present who will assist you during these proceedings. When your case is called, the property owner or any agent for the property owner or any witness that you may have should come forward to the podium on the left side of the room. When asked, please speak directly into the mic and say aloud your name, your business or mailing address, and your relationship to the property. If you are not the property owner or an attorney representing the property owner, then you must present a notarized power of attorney in order for your testimony to be taken on behalf of the property owner. For new cases, you will be asked for the record if you are aware and understand the violation that is being heard today, and do you understand what is required to resolve the violation. Please answer after this occurs. The city will present its case first, then the property owner violator will be given an opportunity to testify on their own behalf, bring forward any witnesses to testify, and to present evidence and photos, and to cross-examine any city witness. Following the case presentation, I will issue a finding of fact on the case. If I find that a violation of the city code does exist or existed on your property, then depending on the case type, I will set an abatement date, that is a date to resolve the violation, for the violation to be cured and resolved, or for repeat or very serious violations, I will impose a daily fine amount. For new non-repeat cases, my order will include an abatement date by which you must resolve the violation and a daily fine amount that I may impose in the future at a future hearing date should the violation not be resolved by the abatement date. If I find sufficient cause to postpone enforcement action at this time, we will table the case, proceeding to another hearing date in the future. If you do not agree with my finding of fact or ruling, then the property owner may appeal the administrative order to the circuit court. An appeal must be filed within 30 days of the date of execution of the administrative order to be appealed, that is, from it being signed. In accordance with Florida statutes, if a person decides to appeal any decision made by the special magistrate with respect to these proceedings, the person will need a record of the proceeding. The record includes testimony and evidence upon which the appeal is based. The cost of obtaining the verbatim record shall be the sole responsibility of the appellant, the person appealing, and it is recommended that persons who plan to appeal the case should provide their own court reporter. Pursuant to city codes, if the City of North Miami prevails in prosecuting the case before the special magistrate, that is, if the city wins, the city shall be entitled to recover costs in prosecuting the case. The current cost assessment is $100 per case. Once the city records an order that imposes a fine and authorizes a lien against the property, the city will charge an additional administrative fee to record and release a lien. If you are giving testimony today on any case, anybody who's going to speak, please rise, and you're going to be sworn in, okay?
If you're going to give testimony tonight, and if you're able to stand, if you can't, you don't have to. Please raise your right hand and take the testimonial oath. Do you solemnly swear or affirm that the testimony you're about to give in this proceeding will leave the truth, the whole truth, and nothing but the truth? Please say I do. I do. Thank you. You may be seated.
Okay, now the Code Compliance Manager will announce any additions, corrections, or deletions to the hearing agenda, and afterwards we will call the first case.
Good evening, Your Honor. We do have a lot of cases that have complied or will be reset to another hearing calendar. We'll begin with agenda item number 119 Road LLC, case CEMIS 2013-00010 has complied. Item 2, Albert E. Art and wife, CEJ&K 2013-00046 has complied. Item 3, Alberto and Maria
Gabino Cruz, CEMIS 2013-00009, has complied. Item 4. Alpana Pandit, CEJNK 2013-00075, has complied. Item 5. Andral Estimab, KCEEXP 2013-00099, has complied. Item 8. Annalisa Wild, case CESTR 2013-00004, will be postponed to October. Item number 9, Archer Browning, CEEXP 2013-00069, has complied. Turning to the next page. Item number 11, Bayview Towers Condo Association, FYREC 2011-00118, is postponed to November and will be moved to the morning hearing calendar. Item 12, BPI Group LLC, KCEBNP 2013-00066, postponed to November. Item 13, Carlos Leva and St. Heavens Osias, CEIVY 2013-00170, is removed from the calendar. Item 14, Catherine Allen Zubizarreta, KCE EXP 2013-00119, has complied. Item 16, Charles Wells and Jill Patterson, CESEA 2013-00001, will be postponed to December. Item 17, CNA Unlimited, CEJNK 2013-00077, has complied. Item 19, City Mortgage Incorporated, CEIVY 2013-00156, has complied. Turning to the next page. Item number 20, Corey and Lisa Gittner, CESRR 2013-00005, has complied. Item 23, David Ronda, CEMHO 2013-00024, has complied. Item 24, David Schultz, CEFAW 2013-00041, is removed from the calendar. Item 26, Dianette Ramos and others, CEPFY 2013-00099, is complied. Item number 27, Dominic Borghese and Barbara Ann Larson, CEBLR 2013-00023, has complied. Turning to the next page. Item number 28, Dr. Albert and Beverly Rossman, CELSC 2013-00001, postponed to October. Item 30, Eddie and Elia Izadron, CEECS 2013-00005, is complied. Item 31, Eileen Nowak, CEEXP 2013-00110, has complied. Item 33, Emmanuel and Gilberte Gedeon, KCE ODS 2013-00058, has complied. Item 34, Erica Chambers, CEIVY 2013-00085, has complied. Item 36, Ernest L. Renzetti Jr., CEIVY 2013-00171, has complied. Item 37, Fannie Mae, CEFAW 2013-00024, is postponed to October. Turning to the next page, item 38, Faye Bridges, CEIVY 2013-00167, is complied. Item 39, Felix Cohen Trust, CEBNP 2012-00109, postponed to October. Item 40 and 41, CEB Francisco Lopez, CEBRD 2013-00005, and CEEXP 2013-00086 have both complied. Item 45, Gessner and Jeanette Millord, case CEWAL 2013-00005, has complied. Turning to the next page, Helen Arbus, CEBLR 2013-00030 has complied. Item 47, Helen E. Wilbur, KCEXP 2013-00042 is postponed to October. Item 50, HSBC Bank USA, KCEPOM 2013-00013 is complied. Item 51, Ingrid Elliott, CEWAL 2013-00004 is complied. Item 52, Jackson and Marie Toussaint, CBNP 2013-00025 has complied. Turning to the next page, item number 55, Joseph Ridore, KCEMHO 2013-00004 is complied. Item 56, JP Morgan Chase Bank, CEEXP 2013-00102 is off the calendar. Item 57, Juan Arturo Estevez, KCEOSV 2013-00020 has complied. Item 58, Julian Noel and Edith Razom, KCEJNK 2013-00059 is complied. Item 59, Kaja Holdings LLC, KCEFAW 2013-00044 has complied. Turning to the next page. Item number 61, Lilas Toussaint, KCEFAW 2013-00038 has complied. Item 63, Louis H. Quijano, KCE EXP 2013-00103 off calendar due to change in ownership. Item 64, Manuel Gerges, KCE XP 2013-00114 is complied. Item 65, Manuel Alejandro Ortega and Muriel Avendano, KCE MHO 2013-00032 has complied. Item 66, Maria O'Morero and Osvaldo Martinez, CENUS 2013-00007 has complied. Item 67, Marie A. Cherry and Exil Saint Vilus, CEPOM 2013-00014 has complied. Turning to the next page. Item number 69, Marie Rosette Charles, CEIVY 2013-00162 has complied. Item 70, Marie Rosette Charles, CEJNK 2013-00068 has complied. Item 73, Mikhail Lancre, CENUS 2013-00010 has complied. Item 74, Miguel Suarez and Miladies Vasquez, CEPFY 2013-00096 has complied. Turning to the next page. Item 76, Odris Modé and Rosemarie O'Day, CEIVY 2013-00094 have complied. Item 77, Philip and Samantha Shakespeare, CEFAW 2013-00047 has complied. Item 78, Pierre F. and Marie F. Lamar, CEBNP 2013-00055 has complied. Item 79, Rachel J. Reeves, CEMIS 2013-00004 is postponed to October. Item 80, Rafael Pichardo, KCEXP 2013-00111 complied. Item 81, Raul and Marie S. Vargas, CEBLR 2013-00028 have complied. Turning to the next page. Item 84, Richard Basola and Linda Basola Adams, CEIVY 2013-00172 has complied. Item 87, Timothy Gerard Lazarus, CEBLR 2013-00029 has complied. Item 89, Valkyrius Guerra, CEBNP 2013-00060 has complied. And turning to the last page, case 90, Yolanda Alter, CESRR 2013-00007 has complied. And item 92, Yolanda Estaquio, KCELSC 2013-00005 has complied. Your Honor, those cases have been removed from the agenda. If I called your name and this case and your case number, you are free to leave. Your case will not be presented this evening.
Okay, the agenda is so corrected, and we're able now to proceed to new business.
Thank you. We're going to begin with agenda item number 29. Item 29, Code Officer Kearson's case for the property owner Eddie Garcia, who owns the property at 1865 South Hibiscus Drive, case CEBNP 2013-00059. This is a new case that was opened by Code Officer Kearson on July 19, 2013. And good evening.
Good evening.
Please state your name for the record and your relationship to Mr. Garcia.
My name is Darren Schwartz. I'm a tenant who resides in the house owned by Eddie Garcia.
And do you have a power of attorney from Mr. Garcia?
Yes, sir, I do.
Thank you. Would you present it at this time for the magistrate to review? Thank you.
It is not notarized, but it is signed, and it attaches the lease, so I will deem it sufficient.
Thank you. Okay, we will introduce that as property owners one into the record, and I will. Do you need a copy of this?
That's your copy.
Thank you. All right, this is a building no permit case for the erection of a fence without a building permit. Code Officer Kearson will present the case, and then Darren, Mr. Schwartz afterwards. If you have any questions, you can ask the code officer any questions and then present your case to the magistrate.
Okay. Thank you.
We'll begin with Mr. Kearson.
Ivy Kearson, City of North Miami Code Compliance Unit of the North Miami Police Department. Property address is 1865 South Hibiscus Drive. This is a non-homesteaded property. There are no life safety issues on the property. The violation was first observed back on July 19th. Then on the 22nd of July, I issued a civil violation ticket because I found that there was no permit for the actual fence that was erected. It was a chain link fence. Check the files, our records today. There's still no permit that was issued. I'd like to submit the pictures for the record.
Please.
Mr. Schwartz, is this the house that you are currently renting?
Yes, sir.
Thank you.
I note a chain link fence around the property. Behind some plants.
Your Honor, through you to Mr. Kearson, approximately how many linear feet would you guess that this the new fence constitutes? Is this the whole yard or just a small portion?
It's a portion of the yard. I'll say, if I had to guess, I'll say it's about roughly maybe about 150 linear feet.
Okay. All right. Thank you. We just want to get some idea of the scale and how much work this is. Thank you.
You have anything else you want to add?
No, the pictures speak for themselves, and the fact that there's still no permit that was applied for to date. I did speak to the property owner, Mr. Garcia, this morning, and he did advise me that his tenant would be here, and he admits that there's still no permit on file.
Okay.
And like I stated
And you-
earlier, I did issue a $500 civil violation ticket.
Okay. And you did check the permit status recently, right?
Yes, I did. I checked it about 5:45.
Okay, very well. Sir, what do you say?
Basically, you're correct. No permit has been pulled as of yet. I'm waiting for the owner to come up with a survey. He lives in El Paso, Texas. If he cannot come up with a survey, he already understands that we need to get a new one in order to get a permit. You had mentioned July 19th you visited the property, and then July 22nd you issued the 2 violations. What I got was July 22nd was a courtesy notice for 2 issues and then 2 violations. The only thing I'm asking for is actually more time right now. I feel that the courtesy notice should have included all 4 issues. I'll just basically say the courtesy notice talked about a car parked in the front lawn, which was removed immediately. It spoke about a basketball goal that was on a swale, which was removed immediately. A couple furniture items which were in front of the house, which were removed immediately, and then the violation for the fence, which was put up without a permit. There was a portion of the fence already there. I was not aware that the permit had to be pulled just to continue the fencing. I'm just asking for more time to be able to pull a permit once we get a new survey or the owner finds a survey for the property so we can be in compliance.
Well, okay. The notice did apparently address a series of violations, but it did include the fence, as I understand it.
Yes, it did. But the courtesy notice did not, because of the fact that the fence was constructed without a permit, and we have a strict policy about building without a permit, and that's something that it was so blatant. Everyone knows you can't just put up a chain link fence of that size without obtaining a permit. So that's why I went ahead and did that. And he had they had the right to appeal the ticket. I don't know if he did that, but I mean, regardless, there's still no permit.
What was there an appeal of the ticket?
That would not be considered at this hearing.
Okay.
The issuance of any civil tickets that would be brought up at a different hearing calendar.
Okay. Well, it's been August. And now September. I mean, it's been over a month. And I think a survey is not that difficult to get just for that part of the property. What does the city recommend in this respect?
A question through you, Your Honor, to Mr. Schwartz. How much longer do you think it will be before you're able to obtain a survey or order a new survey?
I can order a survey immediately, but the owner wanted to get a couple more days to dig through records because he moved to El Paso to see if he could find his existing survey before spending the money on the new one. But I can let him know tonight about the hearing, but should he want to order a survey tomorrow, we'll do so.
Okay. Your Honor, since the code office testified and presented evidence that a violation of city code does exist at the property, and hearing that also from Mr. Schwartz that they could order a survey immediately, and your options are either to table the case for 30 days to allow Mr. Schwartz to obtain the survey and apply for the permit, or to go ahead and adjudicate the case at this time. Code Officer Kirsten, do you have any problems with tabling the case for 30 days?
No, I don't.
Okay, this case will be tabled till the next hearing date of
October 2nd.
October 2nd. And, I think that it can be considered at that time. If it has been cured at that time, so be it. Will be deemed abated. But if it is not cured at that time, I would recommend the $100 charge be assessed and a fine of $50 a day.
Okay.
If not resolved fully by that time.
Understood.
Do you understand?
Mm-hmm.
Okay.
So, Mr. Schwartz, the ruling is that you haven't, case is tabled till October 2nd. We recommend you go ahead and immediately get a survey, and once the survey's in hand, go to the building department and apply for the permit.
Yes, sir.
Should that not occur before October 2nd, you'll get another notice to appear at court. And that time, the magistrate has ruled that you can be fined up to $50 a day until the permit is issued.
Yes, sir. Understood.
Thank you very much for your appearance
Thank you.
tonight, and thank you. Okay, we're ready to go on to the next case, agenda item number 6, Angel Martinez, Mr. Angel Martinez, who owns the property at 2145 Northeast 123rd Street. Case number is CEBNP 2013-00017. This is Code Officer Kearson's case. Good evening, gentlemen.
Good evening. My name is Alfredo Martinez. This is my father, Angel Martinez. We're the owners of 2145 Northeast 123rd Street. What else you need? Phone number and address?
No, sir,
Okay.
that's fine. Thank you very much for your appearance today. This is a building no permit case. We're going to let Code Officer Kearson explain why he cited your property, and then if you have any questions, you can ask him, and then make any statements that you wish.
Thank you.
Mr. Kearson.
Okay, Ivy Kirsten, City of North Miami Code Compliance Office, unit of the North Miami Police Department. Back on April 2nd, I spoke with the new property owner, Mr. Martinez, about a dock that he had that he was rebuilding. That I guess he replaced the wood, and informed him that he needed to apply for a permit for doing that work. At that time, Mr. Martinez was just acquiring the property, and he was also going through a reoccupancy. He had a conditional reoc with our building department, and there were other issues that he had to deal with. And during that time, I issued him a letter letting him know that he needed to do these things. Since then, he has applied for a permit, but the permit has been denied, and it's to the point now where it's been going on for too long, and I can't continue to recheck this case. And I'd like to submit the pictures and the record. Actually,
I know you said the date, but I didn't, repeat the date.
April 2nd was the first time when he was first issued the violation. And I'd like to submit the pictures for the record.
Do you know why the permit was not granted? Yeah, Officer Kearson, if you know, I mean, I'm not telling you to speak for, but do you know why it wasn't granted, if you do?
I actually put in the in there the actual history from the building department. There were some issues about the plans, demo plans that the last entry I think they did that the building department made was on the 3rd, which is yesterday. And they said something about there's some other demo plans or something that he needed to supply. So right now it's actually I guess it's the building department and Mr. Martinez as far as supplying them what they need to in order to go ahead and get this approved.
So this is the permit action report that you're speaking of?
Yes.
So it provide microfilm,
Yes.
provide all dimensions for extension in the waterway and setbacks, provide a readable survey.
Okay. Yes.
Is that what appears to be missing?
right.
Okay.
That's what they said was missing.
Okay. So, and this has been going on since April 2nd, and there hasn't been resolved yet. Is that
Yeah.
what you're
Well, I would like to state that there was some sort of a mix-up with the ownership because the ownership had changed, and the previous owner was getting the notices, and I think I had to actually made the change in our system showing that Mr. Martinez is the new owner back in July. And once I did notify him, once he did get proper notice, I would say he acted, very expediently in trying to resolve the problem by obtaining a permit. It's just that now, I guess he has to satisfy whatever request that the building department is asking of him now.
So we're going by when this owner was noticed, it's actually July, when
Yes.
this owner was noticed. Okay.
Yes.
That's
But
the
I
date.
did speak with him back in April. So he's known since April. So it's just that it was just a mix-up in the mailing. But as you can see, on April the 2nd, I actually did speak with Mr. Martinez, and the pictures that you see there reflect that I took the picture on April 2nd.
And that's when you spoke to him?
Yes. So he's known about it since April. It's just that for some reason.
You spoke to him in April personally?
Yes, I did. Because like I
But
said.
he wasn't noticed for whatever reason, the paperwork till July?
Yeah, for somewhere there was a mix-up because he was going through the reoccupancy, and I guess because Miami-Dade, they haven't actually changed over the ownership and their records, so it was kind of
Okay.
confusing.
Anything else?
No, that's it.
Okay, what do you say?
Mr. Martinez, do you have any questions for the code officer? Okay. Your turn.
Your Honor, first I want to apologize for the appearance tonight. I wasn't able to present myself accordingly. We did purchase a property around 5 months ago. It's around the time that the gentleman's saying. We do have the permit action report from the city. We have the permits here. The problem we're having with the city to get a permit for this is the city has no records whatsoever of this dock, which was existing as far back as I could record since '97, and there was no violation whatsoever on this dock. We made a permit to just replace the existing planks that were on it. It's actually a floating dock, so it's nothing permanent. It's not a permanent structure. It had rotten wood, and we have all specifications for the wood from the engineer of what we replaced it with. So we didn't, the violation says, I think it's -5-60, which is the violation is given building without a permit. I did not build this structure. I just replaced what was existing. Sort of like if I replaced tile on a floor with a new tile. So I have photos here that I can show you from 2006 aerial photos. I went all the way to the county today and I got an aerial picture. The most clear, legible one is from '97 that I can present, that it shows a dock. This same dock was existing since '97. So what, 15, 16 years ago? As far back as they could clearly show it. I didn't own the property. I just got the property 5 months ago. So I've been doing everything that I can, but the city does not want to issue me something because they say they have no documentation of a dock being existent. But yet, when I bought the property, there was numerous violations, which today I finished with everything. I have to give a $5,000 deposit to the city to reoccupy the location, plumbing, electrical, and I did everything today. I'm done. All this is the last thing I have to do to be able to, get my funds back from the city to reoccupy this property. It's the wooden deck, and they have no files. So since that, they haven't been able to grant me my permit. Because they say since I'm replacing something that technically doesn't exist to them, they can't approve it. So this is what I'm going through right now.
Your Honor, a question through you to Mr. Martinez. Sir, how much, what is the cost involved so far in the replacement of the deck materials? Approximately cost for your materials?
Close to $3,000.
Okay. Your Honor, just for a point of information, any work that's done in the city that costs more than $500 is considered sufficient work. Anything below $500 is considered repair and maintenance, normal repair and maintenance. So,
Well, that was, that you're asking a question that I was going to ask. Does 5-60 apply to maintenance? And you're telling me if it's over that amount.
And based upon our code and the Florida Building Code, this type of work, even though I understand exactly what Mr. Martinez is saying, that it's a floating dock. However, due to the amount of money it's required in our city to get a building permit to do repair replacement in excess of $500.
And what is it do you understand what it is the building department wants?
They won't grant me, as far as I know, they won't grant me something because they say they have no records whatsoever but yet this has been since 1997. So they won't grant me a permit for replacing something because technically they state that it does not exist. But yet I have photos and I have proof that it does. Along with, I went to code compliance today to acquire some photos that were taken by law enforcement, Marine Patrol, which states here, I have the report that photos were taken. They couldn't give them to me today. Supposedly they were going to be presented in court, which shows the actual repair in process. So if he could show that, he could show exactly the scope of work that we did. If not, this dock, if I may, Your Honor, was completely unsafe. If this would have been replaced, it would have been a hazard to the city, and I couldn't let my son or my daughter go on it also. So I mean, I don't know what I can do.
Your Honor, 2 questions through you to Code Officer Kirsten. One, have you discussed this case with the building official for the city, John Jackson?
When I initially cited this property, I presented him the pictures, and he clearly stated they needed to obtain a permit for the replacement of the wood planks, and which that's what he was doing. Okay. He was replacing the wood planks, and because of the fact he was doing that, you needed to get a permit.
All right. The second question, again, Your Honor, to Mr. Kirsten and also to Mr. Martinez. Has anyone checked with Durham to see if there was any permit issued for the property in the past for this structure?
No, I did not.
Okay. Mr. Martinez, have you?
As far as they told me, there's been no permit. This does not exist.
Okay.
So that's why they will not issue me a permit. I have all the surveys from the engineers that I've gone through, everything that I can possibly.
Because anything that extends into the waterways, normally Durham has to do a permit and allow it, and they would have a record of it on their microfilm of anything that's done on the waterways or extending into the waterways.
The city of North Miami has no.
The city of North Miami would not, but Durham might. So that's
how far? Yeah, there's a Durham. There's an amount of feet, and I forget offhand what it is. I mean, it's in a Durham regulation, beyond which a certain amount of feet you need a Durham permit. Right. Look, I don't want to advise you, but I can just tell you, and I cannot advise you as a point of general information. You know, when someone, just for everyone to know, when someone buys something, if there is something illegal on it, a structure, a floating dock, whatever it is, the way that a person would show that it is permitted is you look in a city record or a Durham record and you show some permit or you show an inspection of the property at a time when that existed and that wasn't cited. That is how you would say that you're grandfathered or that you're allowed. That is how you prove it. But if you don't have that, then you're left with the fact that there's something there, but if you cannot demonstrate a permit, it's not presumed to be lawful. It's presumed to be unpermitted.
I understand, Your Honor.
So what you're gonna it seems like you've been acting in good faith and trying to do what needs to be done to correct this. But if you can't at some point demonstrate that was permitted at some point by somebody, and the city won't permit it, you may have to remove it.
My question again would come again, why has it fallen under me, the new property owner, since it's been an issue since 1997? It's never been presented to anyone.
Right.
And
right.
I was issued violations before I bought the property from the city of North Miami for other things, but they never told me there was a problem with this, because if not, I wouldn't have bought the property, Your Honor, honestly, in all good faith.
Was there, well, are you saying that there was an inspection of the property by North Miami?
Yes, there was, and there was never any violation of the deck until after I purchased the property, Your Honor.
What record is there of that, though? Because, I would...
The bill of sale stated every violation, because my attorney went through that, every violation that was on the property before I purchased it. I purchased it in that faith.
You did due diligence, and you asked for a search of violations in the city?
Correct.
Do you have that document?
I don't have that document here, but I fixed.
Well, let me tell you, if you had that document here, that might be the end of your case. I mean, if you have that document, but
Your Honor, we could go on about this case for another hour. The city is going to make a recommendation that this case be tabled.
Okay.
And the basis of the recommendation is one, we believe the city has proved that the violation exists at the property. However, listening to Mr. Martinez, and also looking at the building department's record, seeing that they just provided a information to the property owner yesterday with a denial yesterday, and asking for specific information to be provided in order for them to issue the permit, to provide the dimensions for the extension, which is not difficult to do, and to provide a readable survey, which is not difficult to do. And once those items are presented, then the city will issue a building permit for the work that you've done. So in order to give Mr. Martinez time to do that, which is a reasonable expectation based on a denial received yesterday, I would recommend that this case be tabled at least for 30 days to give Mr. Martinez an opportunity to explore his options. Gives you more time. And then we could come back for a report on October 2nd should this not be resolved by then. Okay, that gives everybody an opportunity to move this along without any financial hardship. More to you.
Well, yeah, and but I'd like to add this. I mean, if you have, I know the document that you're speaking of. If you ask for a violation, code violations from the city about this property, and you receive that, you should bring that to the hearing, because I think that's
definitely
that's a very important. You don't have it, so I can't presume, but that's a very important, because if you bought the property and you asked for a list of violations from the city, and they inspected and they gave you a list of violations and not this violation, I think that's an issue.
No, I'm going to bring it because they gave me, to be able to reoccupy the location, they gave me a list of violations, and which is everything that I fixed.
Well, I think that's, you need to bring that. By the same token, if you don't want to get into that has to be a finding about whether this should have been included or not. That's the issue. But if not, you're saying they won't give you a permit, but the city's saying that if you provide a readable survey and if you provide dimensions, you will get a permit. So, I'm simply gonna continue this case till October 2nd, but I think you know what you need to do. You need to you're either gonna have to comply and submit the readable survey and the dimensions to get the permit, or if you're going to claim that you relied on the fact that you're going to have to show a document, and not just come here and say that how you requested that and how you got something in writing signed by the city.
Definitely.
That could be something.
Okay.
Okay.
Thank you for your time. You have a good night.
All right.
Appreciate it. Thank you, Mr. Kirsten. The next case is agenda item 21, David and Valerie Delvart for the property at 12805 Hickory Road. This is Code Officer Kirsten's case, CEBNP 2013-00058. This is a new case open on July 18, 2013, to obtain a permit for a temporary tent in the driveway. Good evening.
Good evening.
Please state your names for the record.
Robert Blees, I'm the tenant.
Angel Garcia, property manager.
Okay, let's hear from the code compliance officer.
Right, we're going to hear from the code officer first, and we'll give you an opportunity to ask any questions afterwards.
Ivy Kirsten, City of North Miami Code Compliance Unit of the North Miami Police Department. On July 18th, I decided to spoke with the tenant in reference to a building with no permit violation that he had on the property. It was for a tent, more like a car cover that he had in his driveway. I spoke with Mr. Lays, and he did, and I informed him that he needed to get a permit, some sort of zoning approval, allowing him to have that structure there. Sent out a violation on the 31st to the owner, and during that time, I've been speaking with the owner and his wife, and they've informed me that because of the fact that the owner lives abroad, he lives in France, and it took them some time to actually get the actual permit application signed and notarized by him in order for them to go ahead and apply for the permit. And I believe now they're here, they do have that information, and now I'd like to just forward the pictures and the file for the record.
Please. How long was this, like this? With the tent up like this?
I think, I'd say the 31st of July was the date that initially spoke with him.
I have to ask you a favor here. Tell me that I was following the agenda, and this must have, what number is this?
21, Your Honor. 21.
All right. Bear with me a moment here. When was the permit obtained for the tent?
There is no permit on record.
There, so it still has not been corrected.
No, it hasn't.
Officer Kirsten, is there anything else you want to add?
No, I will give the tenant the opportunity to speak now.
This in the front of the property, right? Clearly visible from the street, right?
Yes, it is. It's in the front driveway.
Okay. All right. Let me hear from you.
Mr. Blaze, do you have any questions for the officer?
No.
Okay, thank you. Go ahead.
I set up the structure, plead ignorance of the regulations.
Okay.
I'm new to Miami. 2 or 3 days before Officer Kirsten first spoke to me, it was about 10 days before I could come to the office and get the permit application, which I did. Discovered at that time we needed to get the notarization. The owners live in France. Took it to property manager. He sent it off, but it's been delayed trying to get that original copy to us. We have it in hand now, and I'm prepared to submit the application, but it's just been recently we got that back from the owners in France.
You mean you have the permit application signed by the owner?
Yes, I do.
You need to submit that to building. I mean, we can take note of it, but I don't believe you can't submit it to the magistrate because I'm not.
No. Basically, what we're doing is we're trying the steps that have been taken. I even brought the envelope where it was post-dated out of France on August 13, and it was just recently that we just got it in. That's been a time constraint. They wanted to send it via fax, but we couldn't accept it since everything needed to be original and notarized. So all we're doing is we're asking for an extension in order to be able to now that we have the proper documentation from the owner, the approval to go ahead and proceed and ask for the permits to get it permitted.
I have no problem with that, Your Honor.
Okay, Your Honor, question through you to Mr. Blaze. Do you have a survey to accompany the application?
There is a survey is being done because the owner is also doing the
improvement. Any other
the
improvement?
dock in the back.
Okay.
When he did his financing, it was financed in France. They didn't require a survey, but now with what he is doing also, it is required a survey, so it's in the process of being worked on right now as we speak.
Has it been ordered yet, or is
It's already been almost completed because
it's been ordered.
it's already been
All right.
ordered.
Your Honor, the city's recommendation is based upon the testimony of the code officer and the photos in Mr. Blaze and other testimony that we would recommend the case be postponed or tabled till the next hearing calendar, October 2nd, to give the property owners time to, and the agent time to go ahead and submit the application and possibly get this all resolved in the next week or two.
Perfect.
So that would be the
I'll
city's recommendation.
I'll accept that recommendation. Just, when you put that's a very visible fence. It's quite, it's not modest, and it's very, very apparent from the front. So I myself question whether anyone could think that could go up without a permit in any city. So, if my recommendation will be that if it's not corrected by the next hearing date, which is October 2nd, that the court costs $100 be imposed and that you have a $50 a day fine. Okay?
All right, do you
Thank you.
do you understand? We're giving you until October 2nd to get the permit in your hands. And once the permit is issued to you, if you contact Code Officer Kirsten, let him know so he can check the file and then close the case. If you do so, there'll be no cost to you for this proceeding.
By having the permit.
By
already
having
out.
the permit in
By
your
that
hand.
time.
Right.
Okay? And if you have any questions, just stay in touch with our code officer. Okay? Thank you for your appearance tonight. We appreciate it.
Thank you.
Okay, next case will be agenda item number 4343. Ms. Christie's case. And this is for Gary and Marie LaFalle, who owned the property at 932 Northeast 146th Street, KCEBNP 2013-00048. This is a new case opened by Ms. Christie on June 11th to obtain a building permit for the installation of a rear roof overhang. Good evening.
Good evening.
Please state your name for the record.
My name is Gary LaFelle, and that's Marie A. LaFelle for property 932 Northeast 146th Street. We are the owners.
Thank you for your appearance tonight. Ms. Christie will explain why she cited you, and then afterwards, if you have any questions, you can ask her, and then you can speak to the magistrate and tell him what's going on. Okay?
Yes.
Thank you. Ms. Christie.
Translating for my mother. She has a language.
Okay. Are you going to translate for your mom?
Yes.
Thank you.
Thank you.
Vidal and Christie, code compliance. This case was actually brought to the city's attention once we went to the property on an unrelated case. This is for a erection of a rear carport structure at the property. I did speak to someone at the property, which I guess is the son, over the via telephone, and he did mention to me that he would go ahead and apply for the permits for the rear carport. As of today, there has been no application submitted on our records.
And
I do
what-
have pictures for
Please,
the
yeah.
record.
And what was the date that you said that you cited them and discussed this? And
The property was actually cited back in June.
in June. Okay.
Yes.
So we're talking really 3 months ago. Yes.
They were given an extension because they were unable to.
How? I mean, I just like to know these date things.
Well,
Extension
when
to-
when we were made aware of it, they were given 30 days extension, and we had to wait to get them on a hearing calendar.
Okay. So. Okay, they were given till July to.
Pretty much
Yeah.
July, August.
July,
And
August.
that's when.
Okay. Thank you.
Mr. LaFalle, this is the house that you and your
Yes.
mother own. Thank you.
So this rear structure is, I mean, we're not talking about a tent here. Let me just be, we're talking about a wooden structure with support poles that is attached to the
The
dwelling.
main structure of
Okay.
the house.
All right. So this is clearly a permanent structure.
It's not permitted just yet.
No.
It does require a permit.
It requires a permit, but this is clearly a permanent structure.
Yes, it is.
Right, okay. Okay, thank you.
Do you have any questions of the code officer?
No.
Okay. All right, if you would, tell us what's going on.
Yes, we did. I'm the son, and I'm helping my mother in this case. We did receive a notification, and when I came on board and I talked to her, I did talk to the officer to request an extension of what we need to do. Basically, in the back, she had covering that makes it look like it's connected to the structure, but it's not. In any case, we tried to get permit, and we were told that we needed an architect, someone to come in and do a plan and so forth. But due to the economy, they're asking crazy amount of $4,000 to get it done. And even if I wanted to pay the ticket, and we were trying to work it out. At this point, we've been getting the runaround, and I did talk to the inspector. We're trying to get some time to resolve it, but it's not happening. And not to say the least, we are here in good faith. I'm even ready to even take it down because it's becoming such a headache. We did not know the extent of this because the back, that's where she sits. She leaves a car sometimes and so forth. So this is just covering. Of course, yeah, it's not. She's saying that it's not it's not a permanent structure to the house, but it's been there for about a year. Till now,
Right.
did not realize the extent that needed permitting and so forth. But as we are here, we are trying to resolve this and trying to get this out the way.
Well, under the Florida Building Code, a structure like this needs to be permitted, and to be permitted, you need signed and sealed drawings from an architect. And this is not a tool shed or a storage shed or this. Per the pictures, that looks pretty extensive to me. I understand your hardship. What does the city recommend, if anything, relative to this matter?
Well, Your Honor, based upon the officer's testimony and the photographs and the testimony from Mr. LaFalle, he only has two options: either to go ahead and obtain the permit to pay for the necessary architectural plan and the permitting fees, or to remove the structure in its entirety. It is a structural issue. It is it's one of the more serious building permit violations. So your options are either to go ahead and adjudicate the case in order compliance by either obtaining the permit or removing the structure. Under this circumstance, the city would recommend that you adjudicate the case and issue an order and allow sufficient time, maybe 60 days, for either the structure to be removed or for you to obtain a permit. So we'll give you the time you need. But you have to make a decision and go one way or the other.
Yes. Right now, I will speak more with the inspector as far as the steps, because the one is that I haven't been giving the correct step. I'm listening to prior people that were making their statement that I needed to get a survey, and I will look at that option. Not leaving.
It's not just but a survey.
Yeah.
Survey is an issue of you have to make up your own mind speaking to the officials here, but the survey was an issue of someone reconstructing, for example, a dock that was already there. You've added an unpermitted structure without design plans, without signed sealed plans. That's much more serious. It's signed sealed drawings by an architect, and it has to comply with the building code. It's not a minor matter. Lamentably, it's a serious violation. I do think that there is, it's the most, to me, tonight it's the most serious violation I've heard. I do think that there is a violation of an unpermitted structure. I do so find, I have to assess the $100 fee. I will give you 2 months. I will give you 60 days. I will give you till the next hearing date, which is November 6th. That means you have till November 5th, the day before, to abate, which means, I want you to be clear, by November 5th, you either have to have this structure, another full 2 months, but you either have to have it permitted, that is, not in discussions, not in talks, you have to have a permit here at that hearing date from the city, or you have to have taken it down. And you'll avoid any further costs. If that is not the case, my recommendation will be, just so you know, that there be a fine of, $50 a day, starting immediately on November 6th, until it's corrected.
Yes, I understand. One more question, if I may.
Yes.
If I choose to take it down before the exact date, do I require a permit to break it down and get rid of it?
No.
Thank you.
Do you have any other questions?
I explained to my mother, and yes, she understands.
Okay, thank you very much. Good luck
Thank
with
you.
resolving this. I'm sure you can.
Okay. And please stay in touch with Code Officer Christie. Okay. Very good. Merci. Bonsoir. Okay. Next case is agenda item number 5454.
Okay.
Code Officer Clark's case, 54 for Jean Adam Jean-Pierre, for the property address 13875 Northeast 16th Court. Case is CEZPU 2013-00018. This is a zoning prohibited use case. It's a new case opened by Mr. Clark on June 19, 2013, to cease and desist using the property as a multi-rental property. It's a single-family home zoned residence. Miss, good evening. Please state your name for the record.
Yeah, Jane Adam Jean-Pierre, 13875 Northeast 16th Court.
Thank you for being here today. Mr. Clark will explain the violation, and then we'll give you an opportunity to ask any questions or make any statements. Thank you. Mr. Clark.
Wayne Clark, City of North Miami Code Compliance of the North Miami Police Department. This case, as Mr. Graham said, is a reference to renting the property as subdivided into several units when it's supposed to be single-family resident zoned. The owner here is aware of the whole situation. I've been keeping in close contact with him, giving him instructions that he would have to put the property back as one family rental property, in which he did agree to do so. But to date, I saw him he visited the code office this morning and explained to me that he may need more time, but he is making progress. I did go visit the property today, approximately around about 11 o'clock, and then I did find that, around about 12:30, I did find that the property did have some absent tenants. He said that the tenants in the front main house have moved out, and others are coming to follow. It's just that they need more time to find someplace else to live. But I did explain to him that one family could stay there. His choice, I guess. But to date, we're still in the
single
same
family, one family can stay under the
right.
One.
Right. And the property, I'd like to submit the photos for the record, first showing the defendant, which depicts several exterior main doors on every side of the house, north, south, east, and west side of the house. I don't even, 5, 6, maybe 4 or 5. He could tell you better than me, but I do have several different photos of several doors.
Okay.
This is the front of the property, front door, main door. That's one side, I think, is the east side of the property in the back. Okay, so this is your property?
Mr. Jean-Pierre, the photos that you were shown, this depicts your property? Yeah. Okay, thank you. And Your Honor, I have a question through you to Code Officer Clark. Code Officer Clark, this house you inspected with Sergeant Blanchard per the record, did you have an opportunity, did you know how many separate dwelling units are in this house? You said multiple families.
Inside the interior of the property, but I've noticed different people coming out of different doors, locking different doors. So as my testimony, I've seen from my own eyes different families coming and going, and he's not denying.
I'd like you to make note of that next time you're, how many, a few, 2, 3, 4, how many different?
Well, I do know that the main house, there was a family there that me and Sergeant Blanchard, when we visited, spoke with them. And then a day or two after that, I seen another guy and a little girl coming out the other side. But the thing is he's not denying that. He just saying what he told me. He didn't know that he could not do that, and didn't know that it was illegal to do that in that.
But you advised him of that,
right? I explained everything to him in detail. He just was unaware, period, that he was breaking the code ordinance.
All right. So you're essentially, your testimony then is there's at least 2 or more dwelling units.
Most definitely.
Okay, that's
So
what I wanted.
2 or more, right? At least 2.
At least.
All right.
What you see there, those are no duplicate, different position shots. All of those are different entrance doors.
Well, I'm
on the outside of the property.
Yeah, I'm noticing 3 different, 4. Unless my eyes are 1, 2, 3, 4, and 5 different entrance doors.
Okay, that's about right.
Okay, 5 different entrance doors. When was it that you said that you advised him that it was disallowed?
I spoke with him on several occasions, one being July 1st, 2013. I spoke to him, and before then I spoke to him prior to that on June 30th, 2013, and left a message to find out that he was out of town on emergency leave of death in his family of some sort. So I tried to work with him in the beginning.
But you first spoke to him in the beginning of July?
No, I spoke to him, and the first time I spoke to him, it was July 1st. I left a message for him on June the 30th, so he did call back.
But all I'm trying to know, it's a very simple question. When did you first advise him that this was unlawful?
July 1st.
Okay, that's what I want. Sir, what do you say? Thank you.
Yes. I spoke to him that time. I have to leave the country when my family death. And then I called the inspector. I told him, can I have a little more time? And then when I coming back, I called him. And then when I come in sick, I spoke to him again. I tell him I go and try to fix that problem.
Right now, tonight, how many people that are not related by
by
blood or marriage are living or renting or using or occupying that home?
Yeah, only one you have to leave. He tell me give you a little time. He going to move.
One group?
No, one person.
One person.
Yeah, that one is the one I let sleep on some part of the house because he's disabled.
Everyone else is gone.
Yeah.
I mean, you're under oath. Everyone else is gone.
Yeah.
Well, he told me the same thing this morning. So
okay. Well, are you willing to agree to have the city walk through at some point to confirm that?
Yeah. When I finish,
you'll consent to that.
Yeah. When I finish, when the guy move, I have to call the inspector and then come in.
And then you will invite him in.
Yeah.
Okay. What is the city's recommendation in this regard?
Based on the testimony, Code Officer Clark and the photographs and his history, and based on Mr. Jean-Pierre's admission that the house was subdivided, the city would recommend that you issue a finding today and adjudicate the case in favor of the city that violation occurred and still exists today, that the house is still subdivided and needs to be returned to a single-family house, and all the illegal doors have to be blocked up and or permits issued, but that would be up to the property owner to do so. We would recommend at least 60 days for him to do that, because he may have to get building permits or remove bathrooms and other structures.
Well, let's just go ahead and revisit it every 30 days.
Okay.
Because the thing here with me is that you have to be a little sympathetic with the tenants who was not aware of the situation, and it was placed upon them. The big problem is getting those other tenants relocated. Like I said, he can leave one family there. He showed me that it's only one part of the house being used. The rest of it is vacated.
And you're agreeing that obviously it's illegal, and it's not allowed under the zoning ordinance, and it's a devaluation of the property and of the neighborhood. So you're not going to do it anymore.
No.
Right? Okay.
Right.
And so the city wants to check it every 30 days.
Yeah, let's go for 30 days.
Okay.
All right.
I'll tell you what I'm going to do. There is a violation. It's a substantial violation. So there is a finding of guilt that you have unlawfully subdivided and used this home as a multi-family residential unit, it's a single-family home. The $100 court cost is imposed. There is a violation. I'm going to afford you the most time I feel I can reasonably. I'm going to give you 3 months. I'm going to give you till December 3rd to fully cure this. Fully cure this. That means that the house, by that time, it can't be rented ever again, or that's going to be a separate violation you're going to have to face.
Yeah.
But by December 3rd, you have to have it restored to being a single-family home, removing, the doorways that shouldn't be there, the partitions that shouldn't be there, turning a living room into 2 bedrooms, or, all these things that you may have done there. Mm-hmm. And if it's not corrected by December 3rd, I would recommend that there be a daily fine of $100 a day beginning December 4th. It's a serious violation.
Yeah, but really, I'm not divide the house. I got that the guy I left.
Well, whatever, speak to the city
Yeah.
officials, whatever
Yeah.
you need to do to make the house comply
Yeah.
with zoning for a single-family home. Perhaps it's having, I don't know, I know about side entrances in a house and a back entrance, but, 5 entrances in a single-family home is highly irregular. So whatever you need to do to have the home comply,
Yes.
so that's the order. You
Yes.
understand?
Okay.
Thank you.
We give you some paperwork.
And I'll keep in close contact with him and kind of,
Right, monitor it.
Start
and
him off right.
But I want you to understand that in my opinion, if you rent this again to people that are, not your, if you rent this to people not related to you by blood or marriage, again, that's a separate violation. You'll be here on a separate violation, and at that point, it'll be a repeat violation.
Yeah. Okay.
You understand?
Yes, I understand.
Okay, Your Honor, the next case is agenda item 8282. This is Ms. Code Officer Sanders' case cited against Raul and Maria Vargas, who have the property at 12015 Northwest 10th Avenue. KCE PFY 2013-00123. This is a case cited for a new case opened on July 26, 2013 for parking a red 4-door Toyota Corolla on the front lawn. Good evening.
Good evening.
Please state your name for the record.
Mario Vargas and my mother, Maria Vargas, she's the owner of the property in question.
Thank you very much for being here. We're going to have Ms. Sanders explain the violation. Then if you have any questions, we'll give you time to ask her questions, and then you can make a statement. Okay? Go ahead.
Okay.
Shanna Sanders, City of North Miami Code Enforcement Officer. As already stated, this is a violation for a parking of a vehicle on the front lawn of the property. I inspected the property in July and noted the vehicle there. Left a couple of courtesy letters, did not get any response. Sent a notice of violation, no response, so I proceeded to go ahead and send it to the special magistrate. As of today, I went by about 4:30, the vehicle still remains. I'll let the property owner explain why the vehicle is there.
I'm sorry, when you said, I'm sorry, Inspector, when you said you went by at 4:30 today, the vehicle was still there?
Yes, it was parked on the lawn, on the side lawn of the property. I have pictures if you would like to see. But I'll let the property owner explain while it's there. But it is still there at this present time, or at least by 4:30 it was there.
Is there anything else you want to say?
No, not unless they have something they want to ask.
Okay. Mr. Vargas, do you have any questions? Preguntas?
The current question is mine. I don't live at the house, but my cousin has a car that is the same color and same model.
But you own the house. Your mother.
My mother owns the house.
Right. That's the issue here is who owns the house. They're responsible under the law.
We don't have much to say, just that until recently we did not know we were violating the city codes.
But you said that in July.
Yes, I'm showing here July 26th. I first initially inspected the property and noted that it was there.
But when did they become aware of it?
Well, when I usually see violations, I leave courtesy letters at that time.
Did you in this case? Do you know? Or
I'm almost positive I did. Yes.
Okay. Do you remember receiving a letter in July? Seeing a letter there?
Que si recibí una carta sobre este caso alrededor de julio.
Yo no me acuerdo.
She doesn't recall seeing a letter. ¿Cuándo fue la primera vez que miró este caso? ¿Fue esta la primera?
Sí.
In my notations, I show here that I mailed the letter on the same day that I noted the violation I'm showing. And if you look at the docket, it shows on 7/26, send letter that it was mailed out.
On 7/26?
Yes,
Notice of violation letter.
yes, it is.
Okay, that's your business record that you sent the letter, right? Yeah.
Yes, it's noted in my, it's noted in the docket that I mailed the letter.
And it didn't come back to you?
I don't have anything sent back to me, no. Only thing I have here that was sent back to me was the certified notice to appear receipt, signed. The signature is not legible, but I do have a signed
Okay.
receipt that someone received
Okay.
notice.
Okay, the city has a record that they mailed the letter on July 26. There's a record that she says she mailed it. It didn't come back, so the law presumes it went there to the house. The car is still there. What do you propose? Are you going to move it? I mean, you're going to, you know.
We need information on where can we park? Where are we not allowed? Where are we allowed to park? 'Cause they have been living there since 1987, and up to now, we never knew about this.
Your Honor, if I may, the city code requires, it changed back in 2009 and now requires that any cars parked in the front of the house or in the front lawn have to be parked on a paved surface, which means you can't park it on the grass anymore. It has to be parked on a paved surface, which means you have to put in a driveway or a paved surface to park the car in the front yard.
Do you understand that the code changed 5 years ago? You have to park on a driveway, or you have to park in the street. You can't park on the lawn any longer, in the front lawn. It's not allowed in the city of North Miami any longer.
We were not aware of that.
All right, but you're aware of it now.
Yeah.
Are you going to move the car now? I mean, you know. Well,
No,
I want to hear
to
yes.
comply. But the resources are very limited. Can we put black cement blocks?
Well, I don't think so.
How can we?
That's-
What would be the?
You can either extend your existing driveway, or you could put down large square pavers, you know, that allow for drainage, almost like postage stamps. You're leaving the grass, the grama, you know, in between the tiles, the large tiles, and then you could use that as a paved surface. But, you know, the whole idea is if you're parking on the grass, you're killing the grass, and then you have to put down new sod, and you're constantly maintaining the landscaping, and that's a violation. It's an aesthetic problem, and it lowers the property values when the front of the house has all dead grass and landscaping. So,
Okay.
do you think you'd be able to do either move the car or do something soon?
Do we need to have a permit to extend the existing driveway?
If you're going to pour a slab and extend it, yes, you need to have a permit.
But
If you're just
movable
gonna-
blocks?
Movable, large, large tiles, no, that you can buy in a building supply or,
Okay.
you know, Lowe's or Home Depot.
And that will
and-
comply?
Yes, that would give you a paved surface.
No, we're willing to comply. The funds are very scarce, but of course we're willing to comply.
All right. Your Honor, seeing how, based upon the testimony of Code Officer Sanders and the photographic evidence and the testimony of Mr. Vargas, the violation exists and continues, so the city would recommend adjudication at this time. And I would recommend maybe, you know, an abatement date of October 1st. This is something that could be immediately resolved by removing the car or providing a paved surface. I would believe it can be done in 30 days.
Okay, I'm very sorry about this, but you know it has not been allowed for a few years. There is a violation. The violation's been proven, so I have to assess the $100 costs. It is something easy to correct. You will be given till October 1st to abate, to cure it. That is by October 1st. This is up to you, not up to anyone else. You either have to have pavers that comply with the code for the car on it, or you have to have a permitted extension of the driveway, presuming there's some kind of driveway there, or you have to park on the street. I realize your mother's condition, so, and if you have not done so by that time, I would tell you that there would be a fine of $25 a day.
What
So-
was the due date?
October 1st.
Okay.
You have a month, basically, October 1st. The next hearing date here would be October 2nd, which you have to either show, usually the officer will come out again and show that there's compliance, because either the car is not parked on the grass, or you have the pavers that comply, or you have a permitted extension, something like that. And if not, if they come here in a month and it's the same thing again, the $25 a day fine.
Okay, yeah, fully understand.
All right? Thank you. Thank you very much. Good luck. I'm sure you can resolve this.
Okay.
Your Honor, the next case is Agenda Item 8383. Ms. Christie's case cited to Raymond and Chrismine Dalcine for the property address of 1280 Northeast 35th Street, case CEMHO 2013-00027. This is a new case opened on May 10, 2013. Good evening.
Good evening.
Your name?
My name is Crispin Lewis. I'm not Dalson. I'm Javos.
But you're that person, though. You were known as, you were Dalson before.
Oh, yes.
Yes, okay.
Thank you very much. All right, Ms. Christie will explain what's going on at your house. Ms. Christie.
Rita Lynn Christie, code compliance. Property was cited back in May in regards to, actually, I was called to the property by a older gentleman that actually lived at the property, stating that he had several leaks in the roof and holes in the roof. I was able to take pictures. I did send mail to the property owner, who requested additional time to have the situation resolved and possibly get the tenant out of the property. Time was granted, and I have not spoken to her again since seeing her here now. I do have pictures for the record.
So the roof wasn't watertight, it had leaks and...
Well, we were actually in the house taking the pictures of the holes.
Okay. So it's in the pictures?
Yes, it is.
All right.
Ms. Lewis, are the photos that you were shown, is this your house?
Yes, my house.
Thank you.
Oh.
Your Honor, through you to the code officer, Christie or Ms. Lewis, is anyone living in the house right now?
I haven't spoken to her again since we did meet prior to the hearing and me giving her the notice, so I don't know.
Okay. Ms. Lewis, is anyone living in the house?
Me and my daughter.
Okay.
That man do it in the roof. My roof was new. He want to stay free in the house. He broke my house. I don't was there. I was Pompano Beach. I'm just have a job here. I'm going to Pompano Beach. I make a part time. When I come in, my daughter give me the letter for city. I say, what? For paint? I'm paint the house outside. But I don't know about inside. The roof, it was broken in the roof. But only one room broke it. But why he do it? But he want to stay free. That's why he give me trouble. He give my daughter trouble. But I'm go to the court. He go now. He's not in the house.
You had him evicted.
Yeah, he go. And he don't stay.
Your testimony is that. I mean, I just want to understand what you're saying because it's a little different from what you're saying. This man did this on purpose to stay free at your home.
Yeah, he wants to stay free.
Is that what you're saying?
That's why he wants to stay.
Is that what you're saying? That
yeah, he coming in the city. He want to make a picture. That's why he give my daughter a problem. He give my daughter trouble. When I come in, I say, what happened? My daughter say, he broke in the house. I say, what? I want to go inside to see. He told me, I'm not coming inside in the room. I say, yes, because you call city coming in my house. I see the paper face trying to paint in the house. I'm paint outside. But inside, I make a house short sale too. Because my husband and me know I'm divorced.
Yes.
I make a house short sale. The man was in there. He broke inside when he was asleep. Because my roof was new, only one room.
I want to right. I mean, I want to understand. It's just a little. It's very.
I can explain.
Very.
Okay. I can explain what you was trying to say.
Right. I'm not sure. I don't know. She seems to be saying something. This
No,
man did this on purpose,
Yeah,
or I don't.
she rented the gentleman
Okay.
one room in her house.
Yes.
And because he wanted to stay in the house because she was going to sell it, he broke the roof and called the city.
I see.
He poked the ceiling in the room and called the city. So when we came, of course it's broken, so she saw it and she had to evict him. It took a little bit, I guess. But I don't know if the roof is repaired right now. And as she said, it's her and her daughter living there.
Well,
But
this
I don't know if
is
the roof
this
is
is. I
repaired.
want you. Yes.
Yeah.
What?
The situation is she went to the house to a gentleman. That gentleman maybe did the damage on purpose because normally nobody will call the city if.
What was this gentleman's?
The tenant who broke the ceiling. The tenant who broke the ceiling called the city again.
What was his name? What was his name?
La vie de conserve.
Do you have any record of who it is that calls these things in, or no? No, you wouldn't. No. All right.
He was a renter.
And he's been evicted.
He's been evicted. He went to the court. Everything, all the procedures done. He get him evicted.
So this damage, she's saying he caused it.
Yeah, on purpose.
Well, you know, I guess, you know, we're going to have to explain this to her. So I will take this into account. I want her to understand, though, as the owner, she still has to.
Okay.
She's left with a situation in the roof in a home that she owns that she's going to have to repair because it's a code violation. It's a public health problem.
Même si c'est monsieur qui fait ça, malheureusement, c'est vous mettre là comme responsable pour fixer.